Well, a Fox News alert, a New York appeals court just this morning has thrown out President Donald Trump's massive civil fraud penalty. The decision from a five-panel group in New York's appellate division changed the original decision that stood to cost Trump over $500 million. One appeals judge calling the lower court's penalty an excessive fine that violates the 8th Amendment of the United States Constitution. You might remember that New York Attorney General Letitia James' office says despite this decision, they will not be dropping the case. Let's get some thoughts from Andy McCarthy. He's a former U.S. attorney. He is a Fox News contributor. He is on the phone with us. And last summer, you were helping us every single day as President Trump sat in that courtroom. Letitia James, the AG, she happened to be there as well. And at the time, I remember, Andy, you said that you thought this could be the outcome once the appellate...
Okay, stop right there. Because what you just watched on Fox News is exactly the kind of coverage that sounds like news, but leaves out everything that actually matters. A New York appeals court threw out Trump's $500 million civil fraud penalty. And if you only watched Fox News this morning, you walked away thinking Trump just won, that Letitia James lost, that the whole case was lawfare, that Trump is on his way to being, quote, completely exonerated. That is not what happened. Not even close. And the gap between what Fox News told you this morning and what actually occurred in that courtroom is so wide, so deliberately constructed, so carefully designed to mislead that we need to spend real time breaking it down. Because the truth is both more complicated and more damaging to Trump than either side is fully telling you. Here is what Fox News told you. The penalty was thrown out. Letitia James lost. Trump may be completely exonerated. The case was always lawfare. The 8th Amendment saved him. Here is what Fox News did not tell you. The fraud finding was upheld completely. Every single judge on that panel agreed the fraud happened. The financial statements were false. The decade of inflating property values to get better loans from banks was real and documented. The court did not say Trump didn't do it. The court said the specific mathematical formula used to calculate the penalty was excessive under the 8th Amendment and needs to be recalculated. That is a penalty recalculation, not an exoneration, not a vindication, not a finding that the fraud didn't happen. The fraud happened. Every judge agreed. Trump still owes money. How much is still being determined? And the business restrictions, the independent monitor, the compliance requirements, all of it remains in place. That is the story. Not the story Fox News told you. The actual story. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video. Let's go back to the beginning of this case because understanding what actually happened in that courtroom over 2 years requires understanding what the fraud actually was. And it was not subtle. It was not a matter of interpretation. It was documented in Trump's own records with numbers so wildly inconsistent that the judge who reviewed them wrote, "They leap off the page and shock the conscience." Here is what the Trump Organization actually did. For more than a decade, they submitted financial statements to banks and insurers that described the value of their properties at figures that bore no honest relationship to reality. Trump Tower's triplex penthouse, Trump's own home, the apartment he knew better than anyone. His financial statements listed it at approximately 30,000 square feet. The actual size was 10,296 square feet. Not a rounding error, not an approximation, less than a third of the claimed size. That single misrepresentation inflated the value of the penthouse alone by approximately $114 million Mar-a-Lago, the Palm Beach estate. In some years, Trump's financial statements valued it at figures exceeding $700 million, as if it could be developed for residential real estate. But in 2002, Trump had signed a conservation easement permanently prohibiting residential development of the property. He knew. He signed the document. The residential development value was not real. The $700 million figure was not real. and the easement was not disclosed to the banks receiving those valuations. Seven Springs Estate in Westchester County, listed in financial statements as if it would be developed as a luxury residential community. No approved development plan existed. Independent appraisals valued it at a fraction of the financial statement figures. Golf courses, commercial towers, hotels. The same pattern repeated across the entire portfolio, consistently, systematically, substantially higher than any honest methodology would produce, and the discrepancy ran in only one direction, always higher on the statements submitted to private banks seeking favorable loan terms, always lower on the documents submitted to tax authorities where a lower value meant lower taxes. The same properties. Two sets of numbers. Hundreds of millions of dollars in difference depending on which government office or which bank was reading the documents. Judge Arthur Engeron reviewed all of it, the financial records, the loan documents, the appraisals, the conservation easements, the tax filings. And in September 2023, before the trial even began, he ruled on summary judgment that Trump and the Trump Organization had committed persistent and repeated fraud over more than a decade. That finding was based on documents the Trump Organization itself had generated. Engeron did not invent the fraud. He found it in the spreadsheets. The trial ran from October 2023 through January 2024. 40 witnesses, 43 trial days, closing arguments in January. The verdict came in February 2024. $354 million in disgorgement, the legal term for returning money obtained through illegal means, plus prejudgment interest at 9% annually that brought the total to over $450 million before the day of the ruling. With continued accumulation, the figure reached over $530 million by the time the appeals court issued its ruling. Trump testified during the trial. His approach, according to Engeron's subsequent description, was to mostly ignore the questions asked and deliver extended political speeches about the unfairness of the case, the malice of Letitia James, the bias of the judge, and the greatness of his company. Engeron tried to keep Trump on topic. He threatened to remove him as a witness if he continued to filibuster rather than answer questions. Eventually, the judge gave up and let Trump speak. Engeron's conclusion about Trump's testimony was precise and devastating. Trump rarely responded to the questions asked, and frequently interjected long, irrelevant speeches on issues far beyond the scope of the trial. His refusal to answer the questions directly, or in some cases at all, severely compromised his credibility. That is the foundation. That is what happened before the appeals court ruling. Documented fraud, a full trial, a $450 million judgment, and a judge who found that Trump's complete lack of contrition and remorse bordered on pathological. Now let's talk about what the appeals court actually ruled, because the Fox News version of this story left out almost everything that matters. The appeals court is a 5-judge panel in New York's Appellate Division First Department. These are not lower court judges. This is the intermediate appellate level reviewing one of the most consequential civil fraud cases in New York history. Here is what they agreed on unanimously. The fraud happened. Every judge on that panel upheld Engeron's liability finding completely. Trump and the Trump Organization committed fraud. The financial statements were false. The decade of inflating property values was real and documented. On the central question of whether the fraud occurred, the appeals court was unanimous. It did. Here is where the court divided: the penalty calculation, specifically the $168 million component representing the interest savings Trump obtained by using inflated financial statements to secure loans at more favorable rates than he would have qualified for honestly. The majority concluded that this calculation was excessive under the Eighth Amendment's prohibition on excessive fines and sent it back to Engeron for recalculation under a more restrictive legal standard. The $126 million representing profits from the sale of the old post office building in Washington that Trump converted into a hotel, the $60 million representing profits from the sale of Ferry Point Golf Course in the Bronx. The appeals court's treatment of these components is still being parsed by legal analysts reviewing the full 323-page opinion. What the appeals court did not do is equally important. It did not say Trump didn't commit fraud. It did not exonerate him. It did not vindicate his claims that the case was a witch hunt. It did not find that Letitia James had no legal basis to bring the case. It did not eliminate the injunctive relief. The independent monitor remains. The compliance requirements remain. The business restrictions remain. Trump and his sons remain subject to court oversight of how they conduct business in New York. The Fox News contributor Andy McCarthy said Trump may be ultimately completely exonerated. That is not what the appeals court said. The appeals court said the fraud happened and the penalty needs to be recalculated. Those are not the same thing. Exoneration means it didn't happen. The court said it did happen. The bill just needs a new calculation. When the penalty is recalculated by Engoron on remand, it is still going to be substantial. Legal analysts who have reviewed the opinion say the recalculated figure is unlikely to be trivial. We are still potentially talking about hundreds of millions of dollars owed as the consequence of a decade of documented fraud. Trump is celebrating a smaller bill. He has not escaped the bill entirely, and the fraud it is the bill for remains permanently in the legal record. Now let's address the Letitia James argument honestly, because it deserves to be taken seriously even as we understand what it does and doesn't mean legally. James ran for New York Attorney General in 2018 on a platform that explicitly targeted Trump. She called him an illegitimate president. She pledged to investigate him and his businesses. She won and opened the civil investigation in March 2019. The investigation's direction was set before the evidence was fully gathered. That is a real concern. It is not a trivial point. When a prosecutor begins with a target and then builds a case rather than beginning with a crime and identifying a suspect, the investigative process carries a different kind of risk. It is possible to build a valid case in either direction. It is also possible when you start with a target to emphasize evidence that fits and minimize evidence that doesn't. The question of whether James would have brought this same case against a real estate developer without Trump's political profile is one that the courts are not well positioned to answer. Courts review the evidence that was presented, not the investigation process that assembled it. Whether other New York real estate developers have similar discrepancies in their financial statements that have never been investigated is a legitimate question of selective enforcement that the legal system does not easily adjudicate. Here is the counter-argument that the appeals court itself implicitly endorsed by upholding the liability finding. Engoron found Trump liable before the trial began. In September 2023, based on a review of the financial records and summary judgment briefing, he ruled that Trump and the Trump Organization had, as a matter of established fact, committed persistent and repeated fraud. That ruling was not based on James's political statements. It was based on documented discrepancies between the valuations Trump's organization submitted to lenders and the actual appraised or assessed values of the same properties. The Trump Tower penthouse was not 30,000 square feet. That is not a matter of political interpretation. The conservation easement on Mar-a-Lago was real. Trump signed it. The discrepancy between what Trump told Deutsche Bank his properties were worth and what he told tax authorities those same properties were worth was documented in records the Trump Organization itself generated. Engoron did not conjure the fraud from political animus. He found it in the spreadsheets, and the appeals court, reviewing his work on appeal, agreed. The answer to was this politically motivated, and the answer to was their actual fraud can both be yes. The political origins of the investigation do not retroactively make the fraud disappear. The fraud existed in the documents before James decided to investigate it. Her political motivation may have determined which documents got examined. It did not put false numbers in the documents. That is the uncomfortable truth that neither Fox News nor Trump's defenders want to grapple with. The case may have been politically motivated. The fraud was also real. Both things can be true simultaneously. And the appeals court confirmed both. Okay, so let's break this down into exactly what matters, because there is a lot happening here, and the implications go far beyond just this one ruling. Point number 1. The fraud finding is permanent, and it is the most important thing that happened in this entire case. Every judge on the appeals court panel upheld the finding that Trump committed fraud. That finding does not go away when the penalty is recalculated. It does not disappear when Trump's lawyers file their next motion. It is part of the permanent legal record. Trump was found by a court of law after a full trial with 40 witnesses over 43 days to have committed persistent and repeated fraud for more than a decade, not accused, not alleged, found after evidence, after testimony, after cross-examination, after appeals court review. That finding follows the Trump Organization, the Trump family, and Donald Trump personally. Banks that do business with the Trump Organization are doing business with an entity that a court found guilty of systematic fraud. That has practical consequences that no penalty recalculation eliminates. When Deutsche Bank's private wealth management division received Trump's inflated financial statements and offered favorable loan rates based on them, they were defrauded. The fraud occurred at the moment the false statements were submitted. The fact that the loans were repaid does not undo the fraud that induced them. Engoron was clear about this. The next lender who receives fraudulent statements might not be so lucky. That is why fraud law does not require an actual loss to establish liability. Point number 2, the penalty recalculation is not an elimination of the penalty, and Trump is still going to owe a substantial amount of money. Fox News told you the $500 million penalty was thrown out. What actually happened is that one component of the penalty calculation, the $168 million interest savings figure, was found excessive under the Eighth Amendment and sent back for recalculation. The appeals court found a mismatch between the penalty and the established wrong. It did not find that Trump established no wrong. When Engoron recalculates the penalty on remand using the more restrictive legal standard the appeals court identified, he is going to produce a new number. That number is not going to be 0. The fraud happened. The disgorgement principle, returning money obtained through illegal means, still applies. The specific calculation methodology changes. The underlying obligation does not disappear. Legal analysts reviewing the full opinion say the recalculated penalty is likely to remain substantial. We are still potentially talking about hundreds of millions of dollars. Trump is celebrating a smaller bill. He has not escaped accountability. He has gotten a revised invoice for the same fraud. Point number 3. The injunctive relief that constrains how Trump does business in New York remains entirely in place. This is perhaps the most underreported aspect of the appeals court ruling. The business restrictions that Engoron imposed beyond the monetary penalty were not touched by the appeals court decision. The independent financial monitor overseeing Trump Organization operations continues. The compliance requirements continue. The new independent director of compliance installed inside the Trump Organization at the company's expense continues. The 3-year ban on Trump serving as an officer or director of any New York corporation continues. The 2-year bans on Donald Jr. and Eric continue. The Trump Organization is still operating under court-imposed restrictions. There is still outside oversight of their business practices. The practical operational consequences of this case for how the Trump Organization conducts business in New York did not change when the appeals court threw out the penalty calculation. The Fox News coverage barely mentioned any of this, because it complicates the narrative of total Trump victory that they were constructing in real time. Point number 4. The Fox News framing of this ruling is a case study in how selective presentation of true facts creates a false impression. Everything Fox News said this morning was technically accurate. The penalty was thrown out. The Eighth Amendment was invoked. Letitia James's office said they would not drop the case. Andy McCarthy said Trump may be completely exonerated, but the sum of those true facts created an impression that is fundamentally false. The fraud finding stands. The injunctive relief stands. The business restrictions stand. Trump still owes money. The recalculation is coming. Complete exoneration is not what the court said. This is how propaganda works in its most sophisticated form. You do not have to lie. You select which true facts to present and which to omit. You frame the facts you present with language that implies conclusions the facts do not actually support. You give your audience the feeling of having been informed while ensuring they understand the opposite of what actually happened. Letitia James's office announced they will not be dropping the case. That is the tell. If this were the total victory Fox News was presenting, James would have no case left to pursue. The fact that she has a case left to pursue tells you everything you need to know about what actually happened in that courtroom this morning. So here is the bottom line. A New York appeals court ruled on Trump's civil fraud case this morning. The 5-judge panel unanimously upheld the finding that Trump and the Trump Organization committed fraud, a decade of inflating property values on financial statements submitted to banks. The Trump Tower penthouse listed at nearly 3 times its actual size. Mar-a-Lago valued at figures that ignored a conservation easement Trump himself had signed. The same properties worth hundreds of millions more to Deutsche Bank than to the New York tax authorities. All of it documented in Trump's own records. The penalty calculation was found excessive under the 8th Amendment and sent back for recalculation. The fraud finding was not disturbed. The injunctive relief was not disturbed. The independent monitor was not disturbed. The business restrictions on Trump and his sons were not disturbed. Letitia James' office announced they will not be dropping the case. Fox News told you Trump won. Fox News told you James lost. Fox News floated the possibility of complete exoneration. Fox News gave you technically accurate facts assembled to create a fundamentally false impression of what happened. Here is what actually happened. A court confirmed that the President of the United States spent a decade defrauding banks. The court is still calculating how much he owes for it. His business remains under court supervision. His sons remain under business restrictions. And the legal process that will ultimately determine the full consequences of his documented fraud is still ongoing. The fraud leaped off the page and shocked the conscience. That is what Judge Engoron wrote in February 2024. The appeals court read that finding, reviewed the evidence, and agreed. Every single judge agreed. Trump is not exonerated. Trump is not vindicated. Trump is a man who committed fraud, got caught, had it proven in court, had it upheld on appeal, and is now arguing about how large his bill should be. That is not a win. That is accountability in slow motion. And the people who were lied to by those fraudulent financial statements, the banks, the insurers, the marketplace, deserve to see that accountability reach its conclusion regardless of how long it takes, and regardless of how many Fox News segments are devoted to spinning each procedural development as a total Trump victory. The fraud happened. The record is permanent. The bill is coming. Stay tuned. Because this case is not over. The penalty recalculation is coming. The appeals to New York's highest court are coming. And the full financial reckoning for a decade of documented fraud is still being determined. We will be here covering every development with the full context that Fox News chose not to give you this morning.